The third element for subject matter in a copyright is fixation. We need a original work of authorship. We talked about originality, we talk about works of authorship. Now we need to talk about this fixed in a tangible medium of expression. So what does it mean? That the author or somebody acting with his or her authority, the author's authority, embodies a work in touchable form. Why? Why fixed in a tangible form? What kind of reasons? Be nice that, your expression, your work is in a fixed, tangible form. There's certainly lots of reasons for it. Some key points to get federal protection. By definition, as we see up here, it has to be fixed. So if it's not fixed, then guess what? It's not at least protected under the federal rules. Maybe there might be some state claim, but that's going to be dependent on the age. Because if you remember from the beginning, and we're going to talk about it when we talk about formalities, is the Federal Copyright Act exempt the states from copyright protection from the federal government, and the federal laws is the sole body of copyright law. The act says 1976, but didn't go into effect until 1978. So from that point forward, we're dealing with federal law. So getting federal protection. Your work has to be fixed. It says so in the statute. When we talk about formalities, there's a registration process. You need something to give them to deposit. You have to give them a copy. And it's really nice to be able to, have something if somebody, when you want to claim infringement. That's my work. Well, how do you know it's your work? Because I said so. It's nice to have it, right? Fixed in something. So, copyright protection exists at that moment. Once you have originality, once you have a work of authorship, and now it's fixed, this is where copyright protection attaches. As soon as you have it in your tangible form, a novel, a letter on paper, a poem on paper. You could take your novel and you can have it in different forms, right? You can actually write it out with your hand. You could type it out on a computer. You can dictate it on a recorder. You don't have to. Right from that point forward, you've got a work that has copyrights to it. You don't need to run down and register. You don't have to put that little funky C symbol on it. You don't have to get it published. You can make more than one copy. You can tell everybody about it. Your copyright protection exists once it's fixed. Okay? So let's take some examples of this. Suppose a jazz violinist improvises a complex new tune while playing at a concert. Does that tune qualify for copyright protection? May very well be original. Sounds like something that would be original when it's a work of authorship because we have a jazz violinist. But is it fixed if they're improvising a new complex tune? No. It's a public performance, live. Doesn't give it. Nope. What if there's another jazz musician in the audience at that moment? And they're like, oh, that's great. And then they went home and they kind of learned it because it's all in their head. And then they recorded it. Can our original jazz violinist claim infringement? No, because it was never fixed. What if the original violinist plays the improvised tune, and after her show, she runs down to the copyright office and fills out a form for registration and submits it? No, because it's not fixed. She doesn't have it fixed yet. How might she save herself? they record it. They have it recorded. We'll talk about when fixation happens in these live performances, but maybe at that point, after she was done, rather than run down to the copyright office, she ran in back before leaving her dressing room and recorded it down. That would have given her copyright protection, as long as somebody didn't do it within that time frame or first. So getting it fixed is key. And you know who has problems with this? Think about some form of entertainer that might have a problem with this fixation. Comedians, right? And their jokes, most of their work is documented. A lot of them can go out and, ad-lib and come up with a new joke on the spot, but it's not copyrightable. Dancers, we talked about dance and choreography being copyrightable, but if you're improvising in that moment, might not be protected. Other countries don't have this fixation requirement, by the way, that a work has to be fixed in a tangible medium. That's exclusive to the United States. When we talk about the Berne Convention, we'll talk about when we talk about formalities, where we kind of run amok with each other. And in this day and age, when we have technology and the advancement of getting works very quickly all over the globe, it seems as though we should have some sort of consistency in the copyright rules, but unfortunately that is not the case. So a couple things about this fixation rule. This was not the rule prior to the last act being implemented. So when it began in 1978, it didn't exist. What needed to happen was that works needed to be published in order for it to be acceptable as copyright, and it had to have one of those little copyright notice symbols on it, the little C in a circle. We'll talk about that when we do formalities, but for purpose of this fixation point, it didn't exist. So a lot of problems occurred with regards to that. And one of the issues that came up was, I'm not sure if you're familiar with the Night of the Living Dead. I used to have a photo. I don't know why it's not on my PowerPoints or how it got removed. It might be in the section on formalities, because I do talk about Night of the Living Dead in formalities as well. It's the movie that gave us zombies. This is when our zombies first came on the scene. And the creators of Night of the Living Dead did not properly do what they had to do. One of the issues was making sure that it was fixed properly. They also had some other formality issues, but what happened was it didn't get copyright protection and it dumped into the public domain, and hence now we have all sorts of zombie movies and books and so forth. But that's where our zombie comes from, and I wonder if in fact they did things properly and had a copyright on the zombie, if the zombie would be kind of more like Mickey Mouse. Mickey Mouse has a copyright on it, and nobody can take and do anything with Mickey Mouse without permission. Be interesting to see where the zombie line went, but I digress. So, we'll talk more about that in formalities. Now that the statute doesn't require, though, publication, what happens? If your work is now copyrightable or has copyright protection at the moment of fixation, but before your work needed to be published, what happened with the law? What did it do? It allowed a lot more works to be covered, right? So now there's a lot more works that are being covered. And infringement before meant just copying a published work. Now we're covering unpublished work. Letters, emails, drafts of work, computer program code, all of those things that get fixed in a tangible medium are protected. And the purpose of fixation, the fixation requirement, I touched on these a little bit. The Constitution says so. It grants Congress the power to give copyrights in the writings of authors. The word writing implies recorded in some form. And it has a broad definition. So it's not literal. It's not just stuck with novels or things that you write. It could be a whole slew of works. It sets the boundaries, right? It allows the author to define what's included in the work. It's kind of like a fence, the fence around the property. This is my work, and this is what is going to be protected. And like I said, it serves as an evidentiary function for proof in court, right? You could have oral arrangements. They are enforceable, but they are definitely hard to prove. The case we're going to talk about when we talk about infringement is a case involving Led Zeppelin. It wasn't the evidence. It wasn't a hard case to prove. The evidence, the judge wouldn't allow the playing of the songs in court. That's what the case turns on. And just using the written composition. But without any of that, it would be very hard. And the argument on appeal was, hey, the court didn't let us play the songs together, so they should have been able to play. But we'll talk more about that with fixation. But it's nice that it creates evidence that you could potentially use in a case of infringement. Tangible medium of expression. So let's talk about what the definition of fixed is. A work is fixed in a tangible medium of expression when it's embodied in a copy or phonorecord by or under the authority of the author, is sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than a transitory duration. Now, I bolded those words. Those are things we're going to talk about and define. We're going to talk about what a copy is versus a phonorecord. We're going to talk about what is considered under the authority of the author and what is sufficiently permanent or stable and something that is more than transitory. So we're going to kind of talk about these things here. So copies. Copies are defined. There are we need a material objects that are not phonographs. That's something else. In a work, or I should say in which a work is fixed by any method now known or later developed, and from which the work can be perceived, reproduced, or otherwise communicated either directly or indirectly. So let's talk about a couple of these things. A work that is fixed by a method now known or later developed. Clearly the writers of the code went, you know what, as technology and as time goes on, technology gets better. There might be other ways that these things can happen, not just what we know now. So it certainly paved the way for later developments. So let's talk about this novel. You can handwrite it. You can use a typewriter. Right back when they passed the act in 1976, that's what we had, typewriter. But now you can put it on a computer. You can put it on a USB stick. You can file on a hard drive. You can still handwrite it. You can have somebody video record you while you say it. All of those things constitutes making a copy of a work. Now, this phonorecord thing has its own definition. So copies apply to everything that's not a phonorecord. And phonorecord is exclusive for sound recordings. And sound recordings are fixed in phonorecords. And back in the 70s, that's all we had was those big, plastic records, phonorecords. And remember, this does not apply to the audiovisual works, those movies, documentaries. This is solely sound recordings are fixed on phonorecords, but now known or later developed, right? Now we have MP3. We had digital recordings. We had CDs. We had tape. So sound recordings go on those, are fixed in those types of items. Everybody else is a copy. They call it a copy because the actual real work is in the mental component of the human being, and you're putting it on something else. You're making a copy of it on something in a tangible form. Okay? All right. I did some examples. Oh, let me ask you this. Can more works, let me flip my thing. Can more than one work be fixed in the same copy? Can you have more than one work in one copy? Sure, right? Think of a phono record of a bunch of songs on it. Back in the day, they called that an album or a CD. A compilation, right? Book of poetry, book of short stories. A film can be about a story or a copy of a story. So yes, you can certainly have more than one work in the same copy. Sufficiently stable form. This is also defined. Fixation must be sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than a transitory duration. Well, how stable is stable? How temporary is temporary? The gist is, because it's not very clear, it's not really litigated all that much. I don't even have a case for you to present on stability, but it's been considered more than temporary, a brief fleeting moment, but it doesn't have to be fixed internally. Doesn't have to be that way forever. So let's talk about some works. What about a tattoo? You designed your own tattoo and had it put on you. Maybe you did it yourself, so you can eliminate the tattoo artist. You did it yourself on your bicep. That would be fixed in a tangible form, and it's sufficiently permanent, right? But how about an ice sculpture? What if you did an ice sculpture of your design? It's not going to stick around forever. Butter sculpture, those of you who go to the New York State Fair, they always have the butter sculpture. Does that fit the definition? It's more than temporary. It's more than around for a fleeting moment. It's definitely not there eternally. Those could constitute copyright protection, those items for copyright. How about if you write something in the snow? Or you're on the beach and you do a poem right before the tide comes in. Short-lived, fleeting moment. How long does it have to be there? Those things might not be considered stable enough. So you have to think about what kind of form you're putting it in. Maybe it comes to you, you're on the beach, and all you have is a stick, and you write it out in the sand, and then your friend comes who has your bag of things, and you grab your phone and you take a picture of it. I think now you would have saved your poem in a tangible form. And as I said, this is not a settled issue because it's not usually litigated, but there's some computers have temporary memory, starting to have some problems in this area. I think there was a couple articles regarding this issue floating out there, and that's going to be one of your assignments, is to find an article about our subject matter, but you can see that under the assignments for more detail. Maybe somebody can uncover a case regarding this stable form issue. All right. By or under the authority of the author. this seems pretty straightforward. It either has to be fixed by the author or somebody under their authority. So a writer dictates his novel to a stenographer, right? But the key here is that, well, even though I have key there, how about another key? Another key is that unauthorized fixation does not count. So if a speaker is giving, an impromptu speech and there's a bootlegger who records it, the speaker doesn't have a copyright because it wasn't fixed and it wasn't with the authority of the author. So the bootlegger can become the owner of that work. And then my question is, does authorization have to be given before the fixation? So say our bootlegger is the only one who records, we'll say a musician's new song that the musician plays live on stage. Hey, I got this new song I'm trying out. What do you think? And the musician doesn't have it anywhere. Can the musician meet the fixation requirement by then going up to the bootlegger and ratifying the fixation, thereby authorizing it? The language of the statute suggests authorization has to be at the time of fixation. So that's our key. Authorization at the time of fixation. I think it could be done right before, but you still have to get it down. Like the copyright comes once it's fixed. So it has to be at the time of fixation. You can't then later go back to the bootlegger and say, oh, that was mine and I give you the authority to record it. Thank you very much. That doesn't work. Okay? This question hasn't been determined by a court either, but when determining copyrightable, it is per the statute at the moment of fixation is probably going to be what's good. It's pretty clear, I think, in my opinion, in the statute. But maybe with this assignment, someone might want to explore and see if a court has ever looked into the issue of when does authority have to happen. All right, let's talk about transmissions. Fixation and transmissions. Suppose that a TV or radio program is broadcast live. What kinds of things are broadcast live? Sporting events, right? The Super Bowl. If a work must be fully fixed before it is protected by copyright, is the live broadcast copyrightable? Because it would be unprotected, right? Someone recording can record it if it's live. Well, the statute in Congress was on that one with 17 U.S.C. 101. A work consisting of sounds, images, or both that are being transmitted, this also helps for concerts and such, is fixed for purposes of this title if the fixation of the work is being made simultaneously with its transmission. So if it's being recorded at the same time that it's being transmitted, then that's what fixation is occurring, and that's when the copyright attaches. So we've all seen those little warnings. This broadcast is owned by the whatever company, whatever station is broadcasting it. So at the same time, if it's a live work and it's being broadcast or transmitted live. Now let's look at the anti-bootlegging provision, because this is another statute under the Copyright Act. And what it does is it imposes liability, sometimes criminal liability, for anyone who makes an unauthorized recording or transmission of a live musical performance. It's very specific, of a live musical performance, or who thereafter distributes the recordings. Clearly, this is attacking those concert goers that are there with their fancy recording equipment, getting live concerts of big shows like Dave Matthews, and Kiss was one of those, and that's one of our lawsuits we're going to talk about shortly. Any sort of rock band, the Grateful Dead, the very big bootlegging. And the artists had gotten together, and 3 states visited this statue and, sought legislation to be passed. Like, this is our livelihood. And yes, the statute says fixed in a tangible medium, but our live concerts are not fixed in a tangible medium, and most of the time they're not being recorded unless it's a special a CD that they plan on putting out of a live performance, like Dave Matthews did in Central Park. That's not being recorded at the same time. They needed some protection. So here came the anti-bootlegging statute, which imposes liability for anyone who makes an unauthorized recording of a live musical performance. However, this was challenged, and let's talk about our statute. Remember, back from sources of law, Congress can only make laws that the Constitution authorizes them to do. And the copyright statute for copyrights and patents, Congress has power to promote the progress of science and useful arts by securing for a limited time to authors and investors exclusive rights to their respective writings and discoveries. So let's talk about these 2 statutes for a second. The bootlegging provision, what's it doing? It's implying that Congress is giving protection to works that are not fixed, right? And we have our copyright statute. It says you need an original work of authorship fixed in a tangible medium. Live musical performance are not fixed in a tangible medium, so what are they doing? They're giving some authorization here against the statute, giving protection of works not fixed, or doesn't qualify as this writings per the statute. There's also no period of protection here. There's no period of protection. The copyright statute has a duration period. There's no duration period here. It's all live musical performances, period. Wherever. So it seems like it's protecting this live musical performance forever. Is that constitutional? That was the question. Can Congress make this law? And there were a few cases, all raising the same issue. I'm only going to talk about one case, but this is the law out of California, Nevada, and New York. All federal cases, all went to the highest level court in those areas. So the Second Circuit, that's New York. The Ninth Circuit, California, and I believe it's the 11th Circuit for Nevada. The United States Supreme Court has not addressed this issue. So if any cases arise within those circuits, this is going to be the law, but that doesn't mean if the issue is raised, Florida, which is in a different circuit, a different answer could occur. But I would think a federal court in Florida will look at precedent. We're doing a little law background here. Look at precedent and review these 3 cases and has the ability to follow or do something different. So the question was this constitutional? Is this creating this anti-bootlegging provision constitutional? And you might be thinking, well, there's all these signs and I go to concerts, recording prohibited, so it must be good, must be okay to do, right? Have this law and actually cite this in some of the signs at events. Well, it was deemed constitutional, and I'm going to tell you why it's constitutional. But the anti-bootlegging statute that allows the protection for live musical performances was not outside the scope of Congress's power. The courts all found that, and I guess I'm assuming you guys know what bootlegging is. Let's just do a recap, right? Folks who are unauthorized go to musical performances or other types of performances but this is exclusive to live musical performances with their recording equipment. And I think I just said what it was. And record the concert, and then they later sell it. Okay, and it's a big market. They from all over the world, and now you can get it all over the world. Before we had the the internet, there was actually magazines where you can look through the classified ads and find bootlegging material, and then you'd have to write the person and see what they had for a list, and it was like a penny saver for bootlegging is what it was. Anyhow, now you can get them on eBay and wherever else on the internet. But I digress again. I love talking about this stuff. So anyway, this statute was deemed constitutional. Congress did have the power to make this law, and the courts found that their authority didn't come from this statute, or I'm sorry, this provision of the Constitution. Where it stems from is their rights under the Commerce Clause to make laws that affect interstate commerce. So the distribution of those materials interstate gave them their power, kind of like trademarks, right? And the trademark law is under our Commerce Clause of the U.S. Constitution. So that makes that particular law with it still doesn't have a duration on it. It's just indefinitely. So that is kind of our exception to fixation, is those live musical performances are protected and imposes, like I said, liability, which could be a civil liability, i.e. those recording artists are looking to be paid back, or it could be even bigger, criminal liability, where somebody, the FBI comes in and arrests somebody and charges them with committing a crime. So that's fixation. So now we have covered what constitutes the subject matter of copyright protection: originality, an original work of authorship fixed in a tangible medium. Our next week's discussion is going to be on ownership. We'll talk about works for hire, independent contractors, and who gets what rights in works created under different types of ownership.